Imagine a world where the most vulnerable among us, children, are left without clear legal protections,
Hmm.
or where family disputes just drag on endlessly, impacting their well-being for years. It's a pretty bleak picture, isn't it?
It absolutely is.
Yeah.
And it highlights why having a strong, dedicated legal framework for children isn't just like a nice to have, it's really a necessity.
Yeah.
It's about building a foundation for their future.
That's precisely what we're exploring today. We're taking a deep dive into South Africa's Children's Act 38 of 2005.
A really key piece of legislation.
Totally. And this isn't just for legal professionals. It's a pivotal framework that touches every single family and child in the Republic. Our mission really is to unpack its purpose, its key provisions, and its real-world significance.
In plain language.
Exactly, in plain language, so you can walk away with those aha moment about how this crucial legislation truly works to protect the youngest members of our society.
And it's vital to understand that this act isn't, some static rule book collecting dust. It's a living, breathing law, constantly evolving. Its last significant amendments were incorporated as recently as May 28, 2025.
Wow, that recent.
Yeah, this continuous adaptation really shows its responsiveness to the complex and, frankly, ever-changing needs of children and families in South Africa today.
Okay, so let's get right into it then. Why was the Children's Act of 2005 even necessary? Like, what problem was it trying to solve?
Well, at its core, this act puts into practice the crucial rights of children already enshrined in South Africa's constitution.
Okay.
Think about fundamental rights like access to family care, essential social services, and critically, protection from all forms of harm. The act makes these constitutional promises a living reality.
And it stretches beyond national borders too, doesn't it? It connects South Africa to broader global commitments.
Exactly. It fulfills South Africa's obligations under significant international instruments. We're talking about foundational documents like the Universal Declaration of Human Rights, the UN Convention on the Rights of the Child, and the African Charter on the Rights and Welfare of the Child. This highlights a sort of universal recognition of children's inherent vulnerability and their right to special protection.
So, beyond just the rights aspect, what's the overarching goal for children under this act? What's the big picture aim?
Well, a key objective is to foster an environment of happiness, love, and understanding. Basically, ensuring children can develop in a nurturing family setting.
Right.
Its broader aims include promoting family preservation, strengthening communities, and protecting children from discrimination and exploitation. And it also specifically acknowledges the unique needs of children with disabilities, making sure they get the support they need to thrive.
Now, here's where the Act introduces its most powerful guiding principle, I think. The child's best interests.
The cornerstone.
It's not just a nice idea. It's stated unequivocally as of paramount importance in all matters concerning a child's care, protection, and well-being. But what does best interests actually mean in a court of law? Sounds a bit abstract.
That's the crucial question, isn't it? And the Act doesn't leave it vague. It actually provides a detailed set of factors that a court must consider when figuring out what's truly a child's best interest.
Okay, like what?
For instance, courts will look at the nature of the child's relationship with their parents or caregivers and, how those adults fulfill their responsibilities. They'll also consider the child's physical and emotional well-being and their developmental needs.
And importantly, the child's own views and wishes are central to this, which I found really progressive.
Yes, their voice is critical, but it's always considered in light of their age, maturity, and developmental stage. It's not just about what the child wants in the moment.
Ah, okay.
And here's a fascinating insight. This isn't just a simple checklist. Imagine a scenario, right? A child expresses a strong wish to stay with a parent, but maybe that parent is struggling, maybe can't provide a stable, safe home. The Act compels the court to weigh these conflicting factors. It often leads to decisions that are incredibly tough, but ultimately safeguard the child's long-term well-being, even if it's not what the child initially wanted. Safety and stability are paramount.
That really puts the principle into stark relief. So with such a comprehensive vision, how is this act actually implemented across the country? How does it work on the ground?
It requires a truly unified approach. The Act mandates that all spheres of government, so national, provincial, and local, must implement it in an integrated, coordinated, and uniform manner.
Okay.
This ensures a cohesive system of child welfare across South Africa. No gaps, ideally.
Let's turn now to how the Act defines family and parental roles. This can often be quite complex, can't it? Especially as family structures become more diverse.
Definitely.
The Act clearly spells out parental responsibilities and rights. What exactly does that encompass?
Think of these as the legal duties and powers parents have regarding their child's upbringing. So this includes providing care, maintaining contact, acting as a guardian, and contributing financially, maintenance.
And who automatically holds these rights? Is it automatic for both parents?
Well, biological mothers, whether they're married or unmarried, automatically have full parental responsibilities and rights.
Okay.
For biological fathers, they acquire full rights if they are married to the mother at the time of conception, birth, or at any point in between.
Right, the marriage link is key there. But what about unmarried fathers? That's increasingly common. How does the Act handle their rights?
This is a crucial area, and the Act is quite specific. An unmarried father acquires full parental responsibilities and rights if they were living in a permanent life partnership with the mother when the child was born.
Okay, so cohabitation counts.
Yes. Or, alternatively, even if they weren't living with the mother, they can acquire these rights if they consent to be identified as the father and contribute to the child's upbringing for a reasonable period and contribute to maintenance for a reasonable period.
So there are conditions.
Yes, clear conditions, and the Act encourages mediation for disputes over these conditions, aiming for amicable resolution outside of court, which is usually better for the child.
That makes sense. It's interesting how the Act accommodates the reality that more than one person might hold parental responsibilities.
Absolutely.
For everyday decisions, co-holders can act independently, it seems.
That's generally true, yes, unless specified otherwise. But for major life choices,
Right.
things like a child's marriage, adoption, significant medical treatment, or leaving South Africa.
Big decisions.
Exactly. For those, the consent of all persons with guardianship is required.
And this is also where parenting plans become incredibly valuable, right?
Hugely valuable. If parents are having difficulties, especially maybe after separation, the Act strongly encourages them to agree on a detailed plan.
What kind of details?
It determines critical aspects like care arrangements, contact schedules, maintenance, schooling, even religious upbringing. The ultimate goal, of course, is that these plans always align with the child's best interests. That's the standard.
The Act also delves into the critical area of children's health. What are some of its key provisions regarding medical treatment?
A significant provision, and quite empowering for older children, is that those aged 12 and older can actually consent to their own medical treatment. Themselves, yes, if they are mature enough to understand the implications. However, there's a distinction. For surgical operations, a child over 12 must still be assisted by a parent or guardian for those.
Okay.
For younger children or those lacking maturity, parents or guardians consent. But what's truly vital here, and sometimes controversial, is that a parent or guardian cannot refuse medical consent based purely on religious or other beliefs if there isn't a medically accepted alternative treatment.
So the child's physical health comes first.
It firmly places the child's health as the priority in those situations.
And how does it handle sensitive topics like HIV testing and access to contraceptives for minors? These must be tricky areas.
They are. For HIV testing, no child can be tested unless it's genuinely in their best interests and with proper consent. That consent comes either from the mature child themselves, a parent or caregiver, or in some specific cases, the children's court.
And confidentiality.
Absolutely crucial. The Act places strict emphasis on the confidentiality of a child's HIV status. As for contraceptives, children over 12 can access condoms freely.
Freely?
Yes.
Yeah.
Other contraceptives can be provided to a child over 12 without parental consent, provided proper medical advice and examination occur, and again, confidentiality is maintained. It aims to empower children with information and protection for their sexual health.
A truly unique provision, and one that directly reflects specific social realities in South Africa, is the recognition of child-headed households. What does this mean in practice?
This is quite something. It allows for the formal recognition and supervision of households where a child, typically an older sibling, is the de facto head, caring for younger siblings.
Oh.
This provision directly addresses the tragic reality many South African families faced, particularly during the height of the AIDS epidemic, where parents passed away, leaving older children to become caregivers.
So how does it work? Is the child just left alone?
No, not usually. While a designated adult typically provides supervision, the child head makes the day-to-day decisions for the household. And crucially, the Act states these households are explicitly not to be excluded from government grants or assistance solely because they are child-headed.
That's so important.
It's an empathetic legal response to a dire social need, ensuring these extremely vulnerable children aren't doubly penalized.
That's a powerful example of the Act adapting to real-world challenges. Now let's explore the Act's robust child protection safety net. This is where the legal system directly steps in to safeguard vulnerable children.
Right, the intervention mechanisms.
Every magistrate's court, for instance, functions as a children's court.
Yes, and their jurisdiction is remarkably broad. It covers everything from protection orders and care arrangements to issues of contact, guardianship, paternity, support, foster care, and adoption. Pretty much anything concerning a child's welfare.
And their procedural approach is quite distinctive, I understand, not like a typical adversarial court.
Exactly. Proceedings are designed to be informal, relaxed, and non-adversarial. The aim is to foster cooperation rather than confrontation, making the process less intimidating and traumatic for the children involved.
And it strongly emphasizes child participation, too, allowing children to have their voices heard in matters concerning them.
Absolutely. Their views must be given due consideration, always based on their age, maturity, and stage of development. It's not just about adults deciding for them.
Does it encourage settling things out of court?
Yes, the children's courts promote alternative dispute resolution. They often refer matters to pre-hearing conferences or family group conferences to try and mediate and settle disputes.
But not always.
There's a critical exception. These informal processes are not permitted in cases of alleged child abuse or sexual abuse. Those require a formal judicial process for safety and accountability.
A vital tool in this safety net is the National Child Protection Register, or NCR. It sounds like a critical safeguard.
It truly is. The NCR is essentially a central database designed to identify individuals who are considered unsuitable to work with children.
What's its main purpose?
Its vital purpose is really preventative. It aims to protect children from further abuse or neglect by flagging unsuitable individuals. It also helps monitor cases and informs planning for child welfare services.
And how is someone deemed unsuitable?
Well, it includes individuals with convictions for severe offenses like murder, sexual offenses against children, child pornography, or if a children's court has specifically found that they seriously harmed a child.
And the consequences for being on this register are quite severe, presumably, preventing individuals from working with children.
Yes, absolutely. A person on the relevant part of the Register Part B is legally barred from employment in positions with access to children. This covers welfare services, child protection organizations, police child protection units, relevant government departments, municipalities.
A broad range.
A very broad range. And here's the crucial enforcement part. Institutions must check this register before employing someone in such a position. It's a mandatory check.
A proactive step to prevent harm. Okay. The Act also meticulously defines what makes a child in need of care and protection. This seems to cover a wide range of vulnerabilities.
Indeed. It's a broad definition. It includes children who are abandoned, orphaned, living or working on the streets, addicted to substances, being exploited, severely neglected, or victims of abuse or trafficking. Essentially any child in harmful circumstances.
And when such a child is identified, what happens? How are they protected?
The Act provides mechanisms for their protection, including, if necessary, removal from harmful circumstances. While removal by a court order is the standard route, police or designated social workers have an emergency removal power. They can remove a child without a court order if that child is in immediate and severe danger, and delaying for a court order would cause harm.
That sounds like a significant power. Are there checks?
Yes, very strict conditions apply. They have to report it immediately and bring the matter before a court very quickly within 48 hours for police, 24 for social workers to ensure judicial oversight and due process.
And what if an alleged offender, maybe in the home, is the source of the problem? Does the child always have to be removed?
Not necessarily. A police official can actually issue a written notice for an alleged offender to leave the child's home and appear in children's court. The court might then issue a prohibition order, keeping the offender away.
So protecting the child in their home sometimes.
Exactly. It provides immediate protection without necessarily disrupting the child's placement, if the home itself can be made safe.
So once a child is formally found by the court to be in need of care and protection, what kind of orders can be issued? What are the options?
The court has a range of options. They can order family preservation services to support the family staying together safely. Or if that's not possible, they can order alternative care.
Like foster care.
Yes, like foster care, or placement in specialized child and youth care centers. For children exhibiting severely uncontrolled or criminal behavior, there's even the option of secure care facilities.
And what's the long-term goal?
Critically, if a child cannot safely return home, the court works towards a permanency plan. The priority is always family reunification if it's safe and possible. But if not, the plan might involve long-term foster care or, ideally, adoption to provide lasting stability.
Speaking of alternative care, the Act details various options. Can you give us a quick rundown of the main types?
Sure. The Act outlines several key categories. You've got partial care, which covers things like daycare or after-school programs for more than 6 children, think creches.
Okay.
Then there's early childhood development, ECD, programs, focusing on holistic development from birth up to school age. Very important. Then, as you mentioned, foster care. This is meant as a temporary lifeline, providing care by an approved foster parent. The emphasis is strongly on trying to reunite children with their families, if safe, and being sensitive to the child's background, cultural, religious, linguistic.
How long does foster care typically last?
Foster care orders usually last 2 years initially. They can be extended by the court, but if reunification isn't looking like it's in the child's best interest long term, the focus might shift towards adoption.
What other residential options are there?
We also have child and youth care centers. These are residential facilities, again for more than 6 children, offering a range of programs: therapeutic, developmental, secure care for high-risk kids, even programs for street children or those awaiting trial.
And drop-in centers.
Right, drop-in centers provide more basic, often immediate services: food, hygiene facilities, maybe help with homework, and other support for vulnerable children who might be living on the streets or in very precarious situations.
And all these places are regulated.
Yes, crucially, all these facilities, partial care, ECD, foster homes attached to agencies, child and youth care centers, drop-in centers, are strictly regulated. They require registration and must comply with national norms and standards.
Moving beyond South Africa's borders now, the Act also deals with expanding families and navigating international child matters. Adoption, for instance, serves a clear purpose under the Act.
Absolutely. The purpose of adoption, as stated in the Act, is to protect and nurture children by providing a safe, healthy environment and promoting what's called permanency planning.
Which means?
Essentially, connecting children to lasting, stable family relationships. It's about finding them a forever home.
And who can actually be adopted?
Any child can be adopted if it's clearly in their best interests, and they are deemed adoptable. This usually means they're orphaned, abandoned, formerly found to be in need of care and protection, or their biological parents are considered unsuitable or unable to care for them.
And who is eligible to adopt? What are the criteria?
Spouses can adopt jointly, a single person can adopt, a biological father born outside of marriage can adopt his own child, or foster parents can adopt a child they've been caring for.
Okay.
A prospective adoptive parent must be assessed as fit and proper, and crucially, linking back to the NCR, they cannot be someone deemed unsuitable to work with children.
Consent is obviously paramount in adoption. Who needs to agree?
Yes, consent is central. It's required from various parties, including the biological parents, if they're known and available, and significantly from the child themselves if they are 10 years or older and mature enough to understand the implications of adoption.
Their voice matters there, too.
It does. However, there are important exceptions where parental consent is not required.
Such as?
This includes situations where a parent is deceased or their whereabouts are unknown despite reasonable efforts. Or, more contentiously, if a parent has abused or neglected the child, consistently failed their parental responsibilities, or is found to be unreasonably withholding their consent to an adoption that is in the child's best interest.
So the court can override unreasonable refusal.
Yes, the court has the power to dispense with consent if it's being unreasonably withheld, and the adoption is clearly the best path for the child.
Once an adoption order is finalized, what's its legal effect? Is it permanent?
It's completely permanent and transformative. A final adoption order legally terminates all prior parental responsibilities and rights of the biological parents or previous guardians.
Okay.
The child is, for all legal purposes, considered the child of the adoptive parents, establishing a full, new, legal parent-child relationship, as if born to them.
And the Act prevents people from buying babies, right?
Absolutely. There are strict prohibitions against making payments for placing a child for adoption or for obtaining consent. The only exceptions are for legitimate documented costs like necessary medical or legal fees or prescribed adoption agency fees.
Now, intercountry adoptions and international child abductions sound particularly complex. How does the Act handle these sensitive cross-border issues?
These are indeed intricate areas. The Act tackles them by giving the force of law in South Africa to two key international treaties: the Hague Convention on Intercountry Adoption and the Hague Convention on the Civil Aspects of International Child Abduction.
And these treaties take precedence.
Yes, these international conventions actually prevail over ordinary South African law if there's any conflict.
Yeah.
The Director General of Social Development acts as the designated central authority for South Africa, coordinating all the processes under these conventions.
So for intercountry adoption, that body ensures children adopted across borders are properly protected.
Precisely. The central authority coordinates the whole process when a child from South Africa is being adopted by someone abroad, or vice versa. They ensure everything complies strictly with both the Hague Convention rules and South African law to prevent trafficking and ensure ethical practices.
And for international child abduction, what's the focus there?
In cases of international child abduction, the focus is on what the Hague Abduction Convention calls the wrongful removal or retention of a child. This usually means a child taken across an international border by one parent in breach of the other parent's custody rights.
So parental kidnapping, essentially.
Yes, that's often what it boils down to. The Central Authority's primary goal under the convention is to secure the child's prompt return to their country of habitual residence.
Are there exceptions? Can return be refused?
There are limited exceptions. Return might be refused if there's a grave risk of physical or psychological harm to the child upon return, or if the child objects and is of an age and maturity where their views should be considered. But the general principle is swift return.
Okay. Finally, a fascinating and often sensitive area that the Act covers: surrogate motherhood. How is this regulated?
It's tightly regulated. A surrogate motherhood agreement must be in writing, signed by all the parties involved, the commissioning parents and the surrogate mother and her partner, if applicable. And critically, it must be confirmed by a high court before fertilization.
Beforehand. Okay. Any other key requirements?
Yes, there's a genetic origin requirement. The conception must use the gamete, sperm, or eggs from at least one of the commissioning parents, or both, if possible. If it's a single commissioning parent, their gamete must be used.
And the legal effect. Who are the parents?
The legal effect is crystal clear from the moment of birth. The child is legally considered the child of the commissioning parent or parents. The surrogate mother and her partner, if she has one, have no parental rights or responsibilities towards the child born from the agreement.
What about termination of pregnancy? Who decides?
While the decision ultimately rests with the surrogate mother regarding termination, the Act requires her to inform the commissioning parents beforehand to allow discussion.
And money. Can surrogates be paid?
Commercial surrogacy is explicitly prohibited. No payments can be made to the surrogate mother beyond compensation for expenses directly related to the surrogacy, things like medical costs, loss of earnings, insurance. It cannot be a profit-making arrangement.
We've covered the impressive breadth of this Act. It's incredibly comprehensive. How does it ensure accountability and that these vital protections are actually enforced?
Well, the Act doesn't just state rights and principles. It has teeth. There's a robust chapter on enforcement and offenses, underscoring its seriousness.
What kind of things are offenses?
It outlines a wide range of offenses. These include things like contravening prohibitions related to harmful cultural practices, such as female genital mutilation. Also, failing to register required child facilities like creches or care centers is an offense, and operating such facilities or even assisting at one while being on the National Child Protection Register as unsuitable to work with children is a serious crime.
And it also targets a direct harm to children. Right. Abuse and neglect.
Absolutely. Child abuse, deliberate neglect, or abandonment by a parent or caregiver are all specific offenses under the Act. So is the failure to provide adequate maintenance for a child, basic necessities like food, clothing, lodging, or essential medical assistance?
Any others worth highlighting?
Yes. Even failing to report known or reasonably suspected commercial sexual exploitation of a child happening on one's premises is an offense. It puts a duty on people to act.
And the penalties, are they significant?
They are significant, reflecting the gravity. Penalties can range from substantial fines to imprisonment for up to 10 years for many offenses. And for repeat offenders, especially for serious abuse or exploitation, the prison term can go up to 20 years. It demonstrates the state's deep commitment to holding people accountable for harming children.
So what does this all mean for you, our listener? What we've explored today isn't just, a collection of legal provisions buried in a statute book.
Not at all.
It's a powerful and, as we've seen, ever-evolving commitment to the rights and well-being of every single child in South Africa, from defining what it means to be a parent in today's world to creating robust safety nets against abuse and neglect and navigating complex international adoptions or abductions. The Children's Act 2005 really strives to create a comprehensive framework where children can genuinely thrive. It embodies that core principle we discussed. The best interests of the child must always come first.
It truly is a foundational piece of legislation. It sets the standards, it establishes the support systems, defines who is responsible for what, and provides the actual legal mechanisms for protection and intervention. It covers everything from individual family matters right through to complex international child protection issues.
Yeah.
It's really a testament to a society striving, imperfectly perhaps, but definitely striving, to safeguard its most vulnerable members.
So, as you reflect on this deep dive, maybe consider the immense responsibility and the adaptive nature that's required of a legal system to protect the most vulnerable among us. What aspects of child protection do you think society, and therefore the law, will need to adapt to most rapidly in the coming years? As family structures keep changing and new social challenges emerge.
That's a big question for the future.
It's a powerful thought, isn't it?
Yeah.
To know that laws like this aren't static. They're living documents, constantly striving or needing to strive to meet the complex needs of real children and real families.